This is a lecture for my professional responsibility class. We're going to be talking about one of the 1.8 rules, and specifically 1.8J, which is a prohibition on sexual relationships with your client and how this can create a conflict of interest for the lawyer. This is 1.8J. Now, before we proceed, I want to mention something to my students really quickly just to kind of frame this in the larger course of conflicts of interest in professional responsibility. First, we already talked about this. We already talked about this with Rule 1.7. The very provisions of this Rule 1.8J are also embedded in the comments to Rule 1.7, which is our general conflicts of interest rule. And there's a reason for that. Having sex with your client creates a material limitation type of conflict. So if you're in a state that has adopted 1.8J, you have arguably violated both 1.8J and sex with your client also creates a material limitation, which will be a violation of 1.7. On the other hand, this is one of the newer rules in the model rules, and therefore there's a number of states who haven't adopted 1.8J yet, because it's a newer rule, and states take their sweet time changing their disciplinary rules. So the ABA added this. Your state may not have this as a standalone rule, but they almost surely have 1.7 or some version of it, and the bar in your state or your state courts are likely to decide that 1.7 implies the same thing because it's included in the comments to Rule 1.7. Also, this is one of our first occasions to mention to my students, keep in mind that the people you work for after you graduate from law school may have graduated from law school and taken professional responsibility a long time ago. And even though they may do CLE courses on legal ethics from time to time, it's possible that some of the lawyers you're going to work for are not aware that the rules have changed in the last 10, 20, 30 years since they went to law school, and you may be more up to date on the ethics rules than some of your supervisors at work. Just keep that in mind. A lawyer, here's our rule. A lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. And so if you're married to someone or you've been dating someone and you're in a sexual relationship and they want you to do their legal work, I still think that's a bad idea because you're not gonna be objective and see clearly and so forth, but you can do that without violating the rule. On the other hand, you can't get sexually involved with your clients. For my students, I have to tell you that this comes up a lot, unfortunately, in family law practice, where why? Because people are talking about their relationships and people and so forth. And so we do have a problem with this, and it creates a conflict of interest. You're not allowed to do it. Here's our comment. It starts with comment 18 to Rule 1.8. Sexual relationships that predate the client-lawyer relationship are not prohibited. Issues relating to the exploitation of the fiduciary relationship and client dependency are diminished when the sexual relationship existed prior to the commencement of the client-lawyer relationship. In other words, we're less worried that you are kind of taking advantage of a vulnerable client and your sort of the power imbalance in the relationship when you're the lawyer and you're representing someone. If you were already in a relationship, we're not worried that the sex is resulting from the power imbalance in your relationship just because you're the lawyer. We do see disciplinary actions every year from lawyers who essentially seduce their clients or basically take sex in lieu of fees. The client can't pay fees and so forth. And the state bars will go after the lawyers when this comes to light and somebody complains. Now, however, before proceeding with the representation in these circumstances, so this is the pre-existing relationship, and this could even apply to your marriage, or if you have a boyfriend or girlfriend that you're in a sexual relationship with. you should consider whether the lawyer's ability to represent the client will be materially limited by the relationship. In other words, I want you to think about the fact that things don't always go as expected with legal representation. You have a lawsuit, and you know what? Sometimes lawsuits, even you lose the lawsuit, or it takes a bad turn, even though you were sure it was going to win. It was a sure winner. Why? Because some evidence that you thought would be admitted gets excluded. All sorts of things go wrong, unexpected things go wrong in litigation. The same is true with transactional work. You're representing a client in a transactional matter. You thought it was straightforward, and then all of a sudden negotiations break down and the deal falls apart. And it happens all the time. And then this creates strain at home, right, with this person that you've been sleeping with. And then so your work is spilling over into your home life, your sex life, and then that is affecting, in turn, the amount of stress you have about the representation at work. Comment 19. When the client is an organization, in case you've been wondering about this, paragraph J of this rule prohibits a lawyer for the organization, whether inside counsel or outside counsel, from having a sexual relationship with a constituent of the organization who supervises, directs, or regularly consults with that lawyer concerning the organization's legal matters. So if you're representing a large conglomerate corporation like Walmart or Google or something like that, the person you're not allowed to sleep with at that corporation is basically the person who hires you and supervises you as a lawyer. And if there's lower level employees or other employees in other divisions that have nothing to do with your legal work that you get in a sexual relationship, that does not violate this rule. Here's our review question for this rule. A client and a lawyer become close as they are working on the client's divorce case. At one point, they become romantically involved and begin a sexual relationship. After a few weeks, they stop having sex and begin dating other people. But the lawyer proceeds with the representation. Is the lawyer in violation of the model rules? A, yes, or B, no. Hopefully you know the answer to that. If you're not sure, you should review the rule.